Hello, welcome to The Scale of Justice. I remain yours on the program, Femi Okeowo. If I am counting right, this would be about the third time any arm of the judiciary is going on strike in the last 20 years or thereabout. It is not commonplace to find the judiciary staff go on strike. Of course, judges cannot even contemplate it because of the code of conduct by which they are employed. But the judiciary staff also are always pressed to go on strike for one reason or the other. And this time it is to press home the autonomy of the third arm of government. And so when the Judiciary Staff Union of Nigeria goes on strike anytime, it holds down a whole arm of government. That is the only place where we find strike holding down a whole arm of government. In other strikes, it holds down part of an arm of government. But the judiciary is an arm of government, and once its staff go on strike, nothing happens in the judiciary. What is being done to stop this from happening again? There are constitutional provisions that guarantee what these judiciary staff are asking for. There is also an executive order which shows that the executive arm of government supports what is already in the Constitution. Of course, there is also a judicial interpretation of what the Constitution also provides for. And so, why would staff have to go on strike to press home this very obvious and constitutional provision? We have tried to talk to one or two judiciary personalities, but they are not people who would come to fight their cause. And so we spoke to a legal practitioner, and to start off this program, we have a slot on our program that we call From the Courts. And since there's nothing happening from the courts, let us use Olabode Arewa's story on the strike to usher in this program, which we call the segment which we call From the Courts.
Litigants, lawyers, and others having one business or the other in the court were surprised on Tuesday morning when they were turned back by the judiciary workers who were on strike.
Of course, it's already affecting the conduct of our business, because I didn't just come here to spectate. I actually came to, follow up some applications, and unfortunately, I can't be attended to. It's already affecting our job, as lawyers. And all we can hope for is that it will not last longer than necessary.
The workers hinged their action on the refusal of state governors to give effect to President Muhammadu Buhari's executive order of May 23, 2020, and 1999 Constitution that judicial autonomy should come into effect nationwide in order to shield the sector from outside interference.
We are talking about the separation of power, check and balances. How can we make it possible without this autonomy? Autonomy is a total, how will I put it? I would say we are still under the control of the executive.
Yes, it's not freedom.
We don't have the freedom. If we are still under the control of the executive, then that means the check and balances cannot be.
Section 5 is vested in the executives. And the members of the executive will have president, his ministers, his PAMSECs, and he can exercise his power in person or through his ministers or any other person he may authorize. But when it comes to judiciary, the powers of the judiciary is vested in courts. So why should other arms of government interfere into our affairs? For example, Section 271 of the Constitution provides, and I quote, the governor, the appointment of the state chief judge of the state shall be made by the governor. Why? We are fighting for their rights. We are protecting their interests. Let them know. Let them know. We want autonomy in the judiciary. That's why we are here.
Other governors of the 36 states recently announced their intention to commence the implementation. The judiciary workers say they would not back down from the strike until the governors match their words with action. In the meantime, the Chief Justice of Nigeria and the President of the Nigerian Bar Association have appealed to the striking workers to shelve the strike in the interest of the country. Olaboderewa, NTA News.
And so that is what is happening in the courts, and of course we expect that possibly by the time you are watching this program the strike would have been called off, but it doesn't change the fact that a strike was called, and it actually stagnated a lot of things in the court. But now let's talk to a legal practitioner as to what he thinks of this strike. He is Sheriff Mohammed, a legal practitioner based in Abuja here. How did we get here? Must there be a strike to enforce a provision of the Constitution?
Thank you very much, but it is unfortunate that we have gotten to the level where we are. If the intent of the strike is to enforce, like you said, I'm trying to quote you verbatim, then it is unheard of.
What else could the strike be for?
Now, while it is lawful to embark on a strike to try to press home a particular agitation, as in this case, the autonomy, financial autonomy of the judiciary, it is not, however, the question is, what we are going through now, is it worth it? I said, no. Reason being that while it is their right, JUSUN's right, to press home for this agitation, to press this agitation to the latter, and get this financial autonomy. But the question is whether they have exhausted all avenues. That's why I have quarrel with.
What are the avenues you think they should have?
Thank you very much. In 2014, JUSUN went to court, Federal High Court here in Abuja, and to seek interpretation. And the court agreed with them, hook, line, and sinker, and gave judgment in their favor. There is currently a subsisting judgment that all the money meant for the judiciary should be paid directly to NGC, from where it will now be disbursed to various heads of court across, from federal to state. Now, if you are in a position of a judgment, and then secondly, there is the President Muhammadu Buhari, had taken a step further to now sign an executive order to ensure that that is actualized. Are we supposed to just go on strike in the face of this? I said, the answer to me, in my humble opinion, is no. When you are in a position of a judgment, you know what to do. So to me, JUSUN, at their last meeting, probably I hold the strong opinion that they did not maybe consider this option I'm talking about, because they have a subsisting judgment. That judgment had not been appealed against. What it requires is enforcement. Have they made attempt to even cite the appropriate people for contempt? The answer is no. Do you understand? Or have they taken steps to attach that money in the consolidated revenue account? Attach it and get it moved to where it's supposed to be. It had not been done. Why do you want to go on strike when you had already taken the most decent, lawful step to go to court? And you had judgment in your hand. So to me, honestly, my brother, you see, the judicial arm of the government is one of the most sensitive and important. This is the last hope of the common man, and where we deliberately wake up overnight to shut that institution down. We're not doing anything good to ourselves. We're not doing anything good to the system.
Can't judges themselves, being the direct beneficiaries eventually, take these processes that you have suggested if they have judgment in their favor?
Their lordships or judges are not members of JUSUN. Get it right. And they were not the ones that went to court. JUSUN went to court as an association. You understand? They got judgment. And in any event, JUSUN are in a better position to get everything done because it affects all of them, inclusive of the judges. Okay. So there was an interpretation. That was a judgment. What they asked for, they got it. Kolawole J, as he then was, of the Federal High Court, if I'm not...
yes,
Gabriel Kolawole gave that very sound and erudite judgment. Do you expect his lordship, Gabriel Kolawole, to go and enforce it? My brother, the answer is no. So to me, JUSUN did not or have not utilized the opportunity they are holding on to. If they did, there would have been no need for this strike. That's why I said from the beginning that honestly it was uncalled for.
There are 36 states, and enforcement must be on 36 states. How do they go about it?
The money,
particularly when the federation account is the money for NJC at the federal level is being pushed to NJC on the frontline charge.
If they have to enforce it, they have to do it from the base where the money is at the national body. Do you understand what I'm saying?
Yes.
Because it is from there that they disburse to states. Now the problem in the whole of this quagmire is the state government, state governors. Yes. They are the state governors who will collect this money and will not remit or give it to their respective judiciary in their respective states. Now, what they are simply saying is that the executive is independent, the legislature independent. They too want to be independent, which is it's constitutional. Yes. And they have the backing of Section 81, sub 3 of the Constitution that insists that all monies in that consolidation revenue account meant for them should be paid to them. It didn't say it should be paid to a third party or to a governor. No. But all along, because of this kind of political mischief that had been going on, these governors collect this money and they don't remit to them.
Why, if the president signed an executive order, why disburse this money to governors?
The effect of that executive order is to halt further disbursement of this money. So I don't know what has happened there, because that's the effect of it. But if you follow, you now say they begin to tell you a lot of products that either they have not been served with that executive order, they will always find one funny excuse or the other to give. So the point I'm making here is that JUSUN had no justification given what the president has even done to sign an executive order in addition to the constitutional provision. If you look at it, it's not just that area, because you've seen Mr. President has equally signed, had equally done similar things for local governments and all that, yes, which had never happened in this country. That's the point I'm making. You know, it's a very salient point. So to me, JUSUN ought to have taken stock of all this. Because, okay, now their actions had affected everybody. If we have this executive backing via this executive order, number 10, and then we have a judgment, come on, let us commence process of enforcement of our judgment. Otherwise, JUSUN has a bounding duty to tell us what has happened to their judgment. What have they done to the judgment? If you have gone to court in this constitutional democracy and you have gotten judgment, what is left for you, in fairness, is to get that judgment enforced. The money is kept somewhere. You can attach that money from the angle or the place where it was kept, where it is kept, and get it from there to NJC, which is what the Section 81 sub 3 of the 1999 Constitution as amended provides for. But they have not done that. All they did was that they met, I think, on in March and issued 21-day ultimatum. If you cannot get what you want by constitutional or lawful means through the court, how do you want to get it through a market approach? Don't get me wrong, yes, it is their constitutional right to go on strike. Yes. But let wisdom prevail. Where there are options, like I pointed them out,
possibly more effective option.
More effective option. Yes. If they have attempted to cite the accountant general or somebody, cite him for contempt, the money would have been out. Or if they feel they will not cite him for contempt, then they take up other steps to attach that money so that it can be. We know what to do. They know what should be done, and then they have the judges, because they are equally beneficiaries. They will not get their support.
For now, the Chief Justice of Nigeria called JUSUN to a meeting and pleaded that they should call off the strike. Was that necessary?
In the circumstance, it has, because he is the head of the court. You understand that in the circumstance, it is necessary for him to do the needful. And what is the needful here? The needful is to ensure that the courts are running. He has a duty to ensure that. But in addition to that, His Lordship should have even advised them, please, go and take this option. It's a much tidier, neater, and more civil in nature to get what you want. And once they do that, if they let them cite that man for contempt, whoever is the other accountant general or whatever that is holding the money and then he's taking it to somewhere. Honestly, nobody will tell him not to take that money anywhere. There are so many other options. They can get that money attached and get it hooked there and move to where it ought to be. So as far as I'm concerned, judicial independence had been granted. It had equally been implemented, quote and unquote. Yes. But what is just left, little steps to be taken here to just get it properly done.
So much on the strike. Let's hope that the state governors that have a different thinking about the third arm of government would key into the constitutional provision. It's either that provision of the constitution is changed to give way for states to have their own judiciary, because actually I have heard some of the governors say that our judiciary system is unitary and it should be decentralized. And until that is done by the Constitution, we think that the financial autonomy being clamored for by the judiciary is a constitutional matter that should be obeyed. To conclude this program, let's reflect on rights as guaranteed by the courts, and let's do that by reflecting on a public book presentation which was written by a senior advocate of Nigeria, Chief Onoja, where a former Chief Justice of Nigeria, Justice Onogen, Walter Onogen, was told to do the public presentation of the book, and it was an opportunity to talk about his ordeal and what he thinks the courts can do to help Nigerians in pursuing their fundamental rights. It's a book on fundamental rights. Let's take Olabode Arewa's story.
That is the prolific author of several legal books, who is a senior advocate of Nigeria, Ogu James Onoja, expounding on the imperatives of knowing the practice, procedure, forms and precedents related to the enforcement of fundamental human rights.
Fundamental rights are a set of rights that have been recognized by the laws and constitutions of nations. These rights are deemed sacrosanct and are associated with a high degree of protection against the invasive tactics of agents of states and individuals. Part 4, that is Section 33 to 44 of the Constitution of the Federal Republic of Nigeria, 1990 and amended, clearly stated these inviolable rights. They are there. These rights, which are enforceable by the court, pursuant to their judicial powers under Section 66 of the 1999 Constitution, ordinarily will be mere wishes of the legislators if there were no mechanism for their enforcement by the court. Fundamental rights are a set of rights that have been recognized by the laws and constitutions of nations. These rights are deemed sacrosanct and are associated with a high degree of protection against the invasive tactics of agents of states and individuals.
The event is the unveiling of his latest scholarly work on the rules guiding application of the Fundamental Rights Enforcement Procedure Rules 2009 of the Nigerian judiciary. This is a book that analyzes the complex but fundamental issues relating to sustaining the rights of human beings. Gathered to witness the unveiling of the book are some of the leading lights of the bar and the bench, not leaving out the silk. Their legal minds interrogated the role of the judiciary in ensuring justice for all.
We are now looking up to the judiciary to interpret the law in such a way that they can expedite dispensation of justice.
You can't operate a rule of law, a democracy rule of law, without the protection of the rights and privileges of the citizen.
The book will also serve as an effective guide for learned colleagues in comprehending and interpreting fundamental rights and its enforcement procedures.
We believe that it will be very useful to the judiciary, the bar, and the generality of the public. It will be a worthy guide to law enforcement agencies because if we go through fundamental rights enforcement litigation, most rights violations come through the agencies.
The event did not fail to capture some of the topical issues of the moment in the country. In Abuja, Olabode Arewa, NTA News.
Yes, that's the much we have for you on the scale today. Thank you for being part of today's program, and we'll see you again.